Terminating employment in Vietnam is one of the most sensitive and legally complex HR processes. While it may seem like a managerial decision, under Vietnamese law it is a legal act subject to strict procedures. Employers who terminate without lawful grounds or proper documentation risk reinstatement orders, back pay, or even public labor inspections. For foreign-invested companies, these risks are magnified. One wrongful termination case can damage reputation, delay projects, and trigger compliance reviews. To protect your organization, every termination must be legally justified, procedurally correct, and professionally executed. 1. Legal basis under Vietnam's Labor Code. Termination of employment in Vietnam is governed by the Labor Code and related regulations. The law recognizes multiple forms of termination. 1. Mutual agreement. 2. Expiry of a fixed-term contract. 3. Completion of work under a contract. 4. Dismissal for disciplinary reasons. 5. Unilateral termination by employer or employee. 6. Redundancy due to restructuring or technological change. And 7. Other lawful grounds under specific decrees. Importantly, unilateral termination by the employer is allowed only for legally defined reasons and must follow statutory notice periods, 45 days for indefinite-term contracts and 30 days for fixed-term ones. 2. Lawful reasons for employer termination. The Labor Code allows employers to terminate employees for specific lawful reasons. These include 1. Repeated failure to perform job duties after written warnings and documented evaluations. 2. Absence from work for 5 consecutive days without legitimate reason. 3. Misconduct or breach of internal labor rules, including theft, dishonesty, or workplace violence. 4. Restructuring, technological changes, or economic reasons that make positions redundant. 5. Employee reaching retirement age, if no agreement for continuation is made. Any termination outside these defined reasons is considered unlawful dismissal, regardless of company policy or managerial discretion. 3. Why most terminations fail in practice. Most termination disputes arise not from unlawful reasons, but from procedural mistakes. Employers fail to document performance reviews, skip written warnings, or fail to invite employee representatives to disciplinary meetings. Others issue termination notices without observing mandatory timeframes or without proof of delivery. Some HR departments rely on global templates that omit Vietnamese legal references. These procedural lapses make otherwise legitimate terminations invalid. The law in Vietnam prioritizes process as much as substance. The how matters just as much as the why. 4. Step-by-step procedure for lawful termination. A compliant termination process should follow these 5 steps. 1. Identify the lawful reason under the Labor Code and internal labor rules. 2. Document performance or misconduct through written reports, witness statements, or warning letters. 3. Conduct a disciplinary meeting, if applicable, with employee and representative attendance and minutes recorded. 4. Issue a formal written termination decision, stating the legal basis and effective date. 5. Settle all payments, salary, unused leave, insurance, and severance, within 14 working days of termination. Following this process not only ensures legal compliance but also builds transparency and fairness in HR management. 5. Termination for redundancy or restructuring. When companies restructure or adopt new technology, redundancies must follow the Labor Code's procedures. Employers must develop a labor utilization plan, consult with employee representatives, and submit the plan to the Labor Authority before termination. Redundant employees are entitled to severance pay, at least half a month's salary for each year of service. Termination without a valid plan or consultation is automatically deemed unlawful. LTS law regularly supports companies in designing compliant redundancy and restructuring procedures that balance business flexibility with employee rights. 6. Severance pay and final settlements. Upon termination, employers must pay all outstanding wages, unused annual leave, and, if applicable, severance pay for employees not covered by unemployment insurance. Employees who have worked for at least 12 months and are not covered by unemployment insurance receive severance equal to half a month's salary per year of service. Payments must be completed within 14 working days from the termination date. Employers must also return social insurance books and tax documents. Transparent and timely settlements demonstrate good faith and prevent post-termination disputes. 7. Handling foreign employee terminations. Terminating foreign employees requires additional legal steps. When a foreign worker's employment ends, the employer must notify the labor authorities, return the work permit, and coordinate with the immigration department to cancel the temporary residence card. Failing to do so may lead to administrative penalties or affect future permit applications. For expatriates, the termination agreement should also cover relocation, tax clearance, and repatriation support. LTS law assists employers in closing all labor and immigration formalities seamlessly. 8. Common mistakes to avoid. Even multinational employers make recurring errors when ending employment in Vietnam, terminating employees without written justification or documentation. Using English-only termination letters. Failing to include labor union or employee representative in disciplinary meetings. Not paying full final settlements within the legal deadline. Neglecting to issue written termination decisions. These oversights turn lawful terminations into unlawful dismissals, leading to reinstatement and double compensation. Prevention is always easier and cheaper than correction. 9. Case example: avoiding a termination dispute. A European logistics company terminated an employee for repeated poor performance but failed to document warnings properly. The worker filed a complaint. LTS law reviewed the case, reconstructed the procedural record, and facilitated a mutual termination agreement with severance payment. The company avoided litigation and reputational damage. This case underscores that early legal guidance ensures smooth, dispute-free exits. LTS law specializes in employment termination advisory for FDI companies. Our bilingual lawyers draft lawful termination documents, advise on proper grounds, and guide HR departments through each procedural step. We also prepare severance calculations, review internal policies, and represent employers in mediation or dispute resolution. Whether dealing with misconduct, redundancy, or mutual termination, we ensure every exit is handled with legal precision and fairness. In Vietnam, lawful termination protects your company's rights, reputation, and future operations. A single procedural error can turn a legitimate decision into a costly legal problem. Don't take that risk. Contact LTS Law today to review your termination procedures, update your internal documentation, and train your HR team to comply with Vietnam's labor laws. End employment confidently, fairly, and 100% legally, with LTS Law as your trusted partner.